Hi, welcome to Jus Cogens, the International Law Podcast. In today's episode, I'm joined by Maria Khan, who is a data privacy legal manager at Security, a US based software company that produces AI software to help companies comply with global privacy data laws. Her work primarily revolves around consent management, cookie consent, data access governance, and AI governance. She has the IAPP, CIPPE, and CIPM certifications which are in European data protection and privacy management. She also has an LLM from the University of Michigan Law School. We'll talk in this episode about the regulatory landscape of AI governance around the world, um, including the nexus between privacy, data protection, and AI governance, and some discussion on enforcement as well. So this discussion will sort of set uh, the stage for AI governance in our following episodes. And I'm very happy to have Maria on the podcast. She was also my batchmate in law school, so this is an interesting podcast for me personally. And without any further ado, we'll get into it. Thank you so much, Maria, for taking out time and being on the podcast.
Thank you, Mary. It's good to to have conversation with you again. It's good. It's been so long now.
Yeah, it's been a while. So yeah, let's dive straight into it.
Yep.
Just in terms of your background in privacy and AI governance in particular, so if you can just like briefly summarize what you've been up to in the privacy and AI governance space, and what's been your journey so far.
Yeah. So as you have mentioned, I work with security as a data privacy legal manager, and our company we produce AI based software that help companies all around the world to comply with data privacy laws. And our clientele is global, and so is the focus of our research. When I started working with security 3 years ago, I was primarily more focused on GDPR and EU data protection laws. But then with the passage of time, I started learning about US and the other data protection laws. And because now, due to the cross border data transfers, many companies they reach out to us and they require a common solution to comply with multiple privacy laws at the same time. And that is because they are subject to multiple privacy laws at the same time, due to the fact that they have offices in multiple locations or they have employees that belong to different residencies. So slowly the focus has become global, and my focus is also now becoming global, that I'm starting learning, shifting from EU and GDPR to also start learning about other laws and thinking about from a global perspective, that how we can ensure how we can help companies to come up with global oriented solutions for compliance with data privacy laws. So I've been focusing a lot on consent management, cookie consent management, data transparency, and AI governance very recently. It's a new field for us to explore because this has come into play very recently. But now many companies are, they are coming to us and they are considering AI governance. And it's a very wide field. It has data privacy implications. It has provisions within data privacy laws, as well as there are specific AI governance laws that are, some laws are in effect and some laws are upcoming. So this is an emerging field, and I'm very very excited, to keep learning about it.
Sure. Yeah. Thanks for that overview. So, just in terms of your understanding of what AI governance is and why do AI systems need to be regulated and governed in the first place, and if they're not governed, what sort of policy and legislative risks do they present to policymakers around the world?
So yes, AI governance can be loosely understood as a term to to govern the AI systems, and it's a very wide terminology in my opinion. It does not limit that. We're not only talking about data governance within AI systems. We're talking generally about AI governance, which can include the outputs as well, which are generated by AI, which is the output which is generated by data. And with the rise of artificial technology in today's times, there are now many risks, and perhaps we can divide the AI risk into two areas. One can be data privacy related risk, and the other risks are other human rights risk. For example, discrimination against individuals or societal biases, or any violation to the fundamental rights of individuals. And in my opinion, even data privacy violations are also considered human rights violation, because I truly believe that data privacy is a fundamental human right. It should be considered as a human right. So, but we can, talk about how these are two separate risks. So, in data privacy risks, if you go into detail of what data privacy risk AI systems can cause. Any risk that is associated with the collection of individuals' data and the subsequent processing of individuals' data. For example, there are data security risks. That is, you're collecting data and processing it, but then that data may be exposed to data breaches or security incidents. Then there are storage limitation and purpose limitation risks. For example, you're collecting individuals' data for one purpose, but now you're processing it for your AI system, and that wasn't the primary purpose of the data collection. Or you have changed the purpose of the data along the way of your AI life cycle. So that is a violation to the purpose limitation principle. And if you are storing the data for an unlimited time period, that is a violation of storage limitation data principle. So now we have seen that with the rise, especially of generative AI, which is largely based on human generated content. For example, ChatGPT, everybody knows about it. And what it is doing, that it is generating output based on human generated content, and it is generating subjective content, and replacing the human minds and replacing the human discretionary powers. Um, so, and as a result, it needs to collect a lot of data. And that is why there are associated data privacy risks and significant risks attached with generative AI. Yes, then obviously there is also a risk of discrimination against individuals. When we are in this world right now, if we take an example of when we are filling an employment application, an AI system can filter the job applications, and it can eliminate certain race, uh, people belonging to certain race or people belong to certain geography to apply to a particular job. And as a result, it results in unfavorable treatment to certain individuals, and that's discrimination that is caused by AI. And that is why AI governance come into play, that now these are all the risks. AI governance will come into play, and it will allow how we can handle these risks and how we can mitigate these risks.
Sure. Yeah, I think that's a very good introduction into what AI governance is and what risks it presents. And I like the fact how you divided it into data privacy risks and human right risks. So just a natural segue is drawing the connection between data privacy, data protection, and AI governance,
Hmm.
because data protection has been around for some time now, and with regulations like the GDPR, being around for like 5 years and more, a lot of the practitioners and policymakers have been trained and familiar with the different fundamentals and principles of data privacy. And now we see increasingly those are being translated into AI governance as well,
Hmm.
with organizations like the International Association of Privacy Professional working on a new certification on training AI governance professionals. So
Yep.
just in terms of the connection and the nexus between privacy, data protection, and AI governance, you've already hinted upon some of those aspects. So I just want to have a general idea of how are all these different areas linked with each other.
Yes, the reason AI governance and data and privacy can be linked to each other is due to the fact of the processing of personal data. So there are AI systems that collect and process personal data, and wherever there is an involvement of personal data, all the data privacy laws come into play. So if you are an AI system and you are using personal data, you will be subject to GDPR and other data privacy obligations depending on the company where you are based and depending on the jurisdiction. And if the AI system does not involve personal data, that can also be the situation, then data privacy laws will not be relevant, and there would be other laws that may be applicable to your company, to your AI system. When we talk about what data protection obligations AI systems can have, it can have all those, the main common data privacy protection principles. For example, the principle of data security. The data needs to be secure. It needs to be protected against any unauthorized breaches or unauthorized access. The second thing is user transparency. The individuals, they need to be informed if they are interacting with an AI system, unless it is clearly evident from the context and circumstances of the use. The transparency principle, um, for users must be informed that they are interacting with an AI system, plus the logic that is being used for any decision making by the AI system, and as well as the data subject rights that are available with the AI system. For example, the right to object to automated decision making. This is the right granted under the GDPR. So there are already provisions within the GDPR and within the existing data privacy laws that can be applicable to AI systems. Um, there is a principle of lawful basis of processing that can also be similarly applicable to AI systems. That if you're collecting data, what is the basis of your processing? On what grounds you are collecting data? And similarly, there are principles such as data minimization, storage limitation, data accuracy. In addition to that, AI systems may have some increased obligations, um, because of the depending on the level of risk they are causing to individuals. For example, if there is a high risk to individuals, then they will have a different set of obligations. Under the GDPR, there is an obligation to conduct a data protection impact assessment if the data processing is resulting in high risk to individuals. And That obligation can also be applied to AI systems that are causing high risk to individuals. And we have seen this in many proposed and upcoming laws. For example, in EU proposed AI regulation, we have seen that high risk AI systems have higher obligations. They have an increased transparency requirements. They have increased documentation requirements, and they have requirements depending on different stages, in the pre-deployment stages and in the post-deployment stage. So uh, this is how the data privacy obligations, they come into play at every single stage of the AI life cycle, in the pre-deployment stage, and then in the deployment stage, and then after the post-deployment stage as well. So any I've mentioned about high risk AI systems. I think any AI risk system that creates high risk to individuals, and particularly to the health and safety or fundamental rights of individuals, those AI systems have increased set of obligations. For example, AI systems that are associated with health, or employment matters, or human education, or human accommodation. And then other AI risk systems, AI systems that are causing a comparatively low risk, will have lower set of obligations. But the common data privacy obligation would still apply to all kinds of AI systems due to the fact that they are involved in personal data processing.
Sure. Yeah. Thanks a lot for that. I think that makes it quite clear in terms of how fundamental the collection, storage, and processing and use of data is common to the work of data privacy professionals and also people who are working on AI governance. And thank you for explaining the details in which different stages of the deployment of AI systems affect how data is used and manipulated. And you previously also talked about how in generative AI models, the large language models data is being scraped and mined around the world, and that's causing a lot of concerns to policymakers around the world. So just in terms of the current AI systems and models that are being used, and how are governments and companies around the world sort of regulating that? Because you mentioned about upcoming regulations such as the EU AI Act and their similar counterparts, which might be coming soon in the US, and even in places like Canada where you're based. So I just want to have an idea of what is the existing system of regulating AI systems um, around the world in major jurisdictions, and what are the sort of the frameworks or guidelines or standards that are generally being used in this regard.
Yes. So as I mentioned earlier, that lawmakers, they can take two approaches. One of the two approaches to regulate AI systems. The first approach is that they can find provisions within the existing data privacy laws that can be applicable to AI systems. And the second approach is to come up with specific laws that are specific to AI systems. And due to the fact that there is an emerging rise and increase in artificial technology, and especially the generative AI, we have seen significant rise this year in generative AI related systems. Now, lawmakers have started coming with specific regulations or specific guidelines for AI systems due to the specific risk AI systems are causing to individuals. So there are laws in place. There are laws in place, and then there are upcoming laws. Other than laws, there are guidelines and standards, and also there are some enforcement actions taken by various regulatory authorities. If we talk about laws, we know that EU AI Act is proposed, and it is expected to come into effect. Uh, um, and then we have Canada Bill C-27, and we have other AI regulations that are expected to come into effect. For example, the UK Data Protection and Digital Information Bill is expected to come into effect in March 2024. And in addition to these laws, there are guidelines in place that are issued by various regulatory authorities. The UK Data Protection Authority, ICO, has issued a specific guidelines on the use of AI. There are guidelines issued by Singapore, by China, and India, and there are voluntary standards as well. For example, NIST AI Risk Management Framework is an industry-wide acceptable standard now, and many companies are relying on this standard for their risk management practice for AI systems. And there have been several actions taken by data protection authorities in relation to AI. We have seen in the last 2 years, data protection authorities all around the world have been very active, and they have taken actions against AI companies. There have been actions against, for example, Clearview AI or ChatGPT, how Italian company data protection authority responded, and how French DPA responded, or Finland DPA. They are taking enforcement actions just the same way they take regular data privacy enforcement actions, and they impose fines, or they impose injunctions or instructions for those companies that are causing AI related risk. So there are a number of ways through which data protection authorities can react to AI systems.
Sure. Yeah, that makes a lot of sense. Thank you. So, just in terms of the different assessment tools and controls that are being used in this regard, so I'm guessing that in your role at Security as the data privacy manager, you must be dealing with organizations and companies which are trying to ensure compliance with existing AI standards and guidelines that you have already mentioned about. So, just in terms of AI assessments and controls and toolkits or anything of that nature, how important is their role in ensuring compliance with such standards?
Yes, I think it is important now, and companies have started realizing that it is very important for them to conduct risk management assessments, risk assessments for AI related systems. And depending on where the company is based or which jurisdiction the company is operating in, it wants to comply with those standards and guidelines. For example, if there is a company that is subject to UK data protection laws, it will follow the ICO, the risk assessment toolkit that has been issued by the ICO, the UK Data Protection Authority. But at the same time, companies also look for industry best practices and standards that can be voluntarily applied. Um, when we talk about the risk management framework in relation to AI, we can also take it in two ways. The AI risk can be part of any privacy assessment, the normal privacy assessments that we conduct, or specific AI risk assessments can also be conducted. If we can go into how the risk assessment should be conducted or what should be the steps. So, in my understanding, the first step of any AI risk assessment is the identification step. You need to, as a company or as an AI system, you need to identify firstly which privacy laws apply to your AI system, and once you have identified which privacy laws apply to the AI system, you will be able to identify the obligations and take further steps. And and identify the purpose of the AI system, identify what and how personal data is flowing through the AI system and how it is processed by the AI system, as well as identify AI actors or entities that are responsible in respective stages of the AI system. So this is the first step of any AI risk assessment, the identification step. The second step would be the identification of threats and vulnerabilities. So once you have determined the purpose of your AI system, now you are in a position to determine what threats and what risk it can cause to individuals, and what are the potential vulnerabilities that are caused by the AI system. And the third step would be to determine the level of the risk. And here, this step is very important. Here, you need to determine whether the risk the AI system is causing is high or low. And you need to identify any privacy obligations or any legal obligations depending on the level of the risk. As I mentioned earlier, that privacy obligations vary depending on the level of the risk. High risk AI systems have a different set of obligations. Lower risk AI systems have different set of obligations. Any AI risk system, for example, if it's an AI enabled video game, it may not be imposed to many transparency obligations or very strict legal obligations. But if that video game is collecting children's data, and children data is sensitive personal data, then it may be subject to some increased obligation. So depending on the level of the risk, depending on the type of personal data you're collecting, and depending on the threats and vulnerabilities it is causing to individuals, you need to determine what obligations the AI system is subject to. So once this is done, now you have identified the privacy obligations, you have identified the purpose, how the personal data is flowing, you have identified the threats, and you have now identified the level of the risk. The next step would be your response to the risk, and that is how you control to a risk. If there is low risk, perhaps you would want to accept the risk. If there are other entities that are involved in the control of the risk, then you will transfer the risk to other entities and will make sure that those entities can help you mitigate the risk. So this step would, your response to the risk would be basically to mitigate the risk, and this is happening all before the deployment stage. You are trying to mitigate and control the risk before an AI system is deployed, and you're now placing controls to do that. And there can be various controls put in place to mitigate the risk. Once that is done, the AI system is deployed. in accordance with controls, the last step would always be monitoring and reviewing the AI system. Because the data keeps flowing, and the you need to keep monitoring that is the data processing being taking place with the same purpose for which you collected the data, or has there been a violation to the purpose limitation principle. And AI systems are information systems, so they evolve over time, and so do the risk to personal data may evolve over time, and that is why monitoring and reviewing the AI system would always be an essential component of an AI risk assessment. So these are the common steps that are part of any AI risk assessment. And if you want to go into specificity, and let's say if you want to say that you want to accept NIST AI risk management framework as an industry best practice, then the NIST AI risk management framework, it has a different set of obligations for an AI risk assessment.
Okay. Yeah, that's really insightful. Thank you for that. So, just in terms of identifying the level of risk, which for me it seems like a challenging task for any organization, given that the tools, the AI systems and models that are being deployed are uh, improving and changing day by day. So the technology itself is evolving at a very rapid rate, and even you talk about the NIST framework and other voluntary standards that companies are using, but just in terms of existing regulations which uh, do not exist in a way which are like specifically targeted to AI systems. I mean, the EU AI Act is being negotiated and it's is facing some roadblocks as it's being finalized. So that also takes a risk-based approach, the act itself, and that's what you're also alluding towards how companies and organizations are going about deploying and developing AI systems. So just in terms of assessing the level of risk and then identifying what are the key privacy data protection obligations that companies have to abide by. So how do companies navigate through those challenges and actually make an adequate assessment of what the level of risk should be? This is just a I'm just wondering how that would how that would happen.
Yeah. Um, Definitely, it's a challenging task. And it will be more challenging for companies that are subject to multiple privacy laws or multi at the same time. Um, and before assessing the level of risk, in my understanding and in my opinion, I would say the first step should always be to identify which laws apply to you, because the level of the risk may differ depending on applicable laws. In GDPR, there's a different definition of sensitive personal data, and there are different obligations that are associated with the data that is used for criminal convictions or for children's data. But that may not be the case in any other law. So you need to identify, first of all, which privacy laws apply to you, and then depending on what data you are collecting, you will have to determine what can be the risk associated with it. If it is sensitive personal data, the risk will obviously be higher. If it is children's data, the risk will obviously be higher. Or anything, the EU AI regulation talks about high risk AI systems. In that definition, they are saying that any AI risk system that is causing violation to the fundamental rights of individuals is considered a high risk AI system, or causing a violation to the health and safety of individuals. That is a high risk AI system. And they have given a long list of examples that you can have a look at, that these are the high risk AI systems. They have given examples, but then the limited or minimal AI risk systems are also present, that do not cause any fundamental rights to individuals, that do not have any concerns for the health and safety of individuals. Any AI system which is also capable of creating biases against specific groups of individuals, that can also be considered a high risk AI system. because it can result in discrimination or societal biases, and that goes against the general fundamental rights of individuals. So, in order to identify the level of the risk, you need to identify the privacy laws that are applicable to the AI system, and then the type of data that you're collecting and the type of output that you will be generating from that data. These factors will help you determine the level of the risk.
Okay, so it seems like from what you have explained in detail, and what we have been talking about, that the key data privacy obligations which have existed for some time now, with the emergence of GDPR and even the privacy regulation and other regulations before that. So those fundamental principles, whether it be data minimization, purpose limitation, they are central to AI governance and will remain central to AI governance in the future as well. I'm also like wondering, you talked about how companies and organizations would have to be wary of making assessments at different stages of their AI system processes, whether it's at the initial design phase and then deployment phase, which sort of draws a parallel with concepts like those of privacy by design, which are in GDPR,
Yeah.
where while companies are at the stage of the entire stage of their systems, where they have, whether they're developing certain product or certain service, they have to keep in mind what sort of privacy or data protection implications any sort of changes or decisions might have in the future,
Yeah.
which I'm guessing might be more challenging with AI systems, because the technology is evolving at a very rapid pace. So they might not be able to preempt all those challenges while designing and deploying those systems. How do you feel about that?
Yes, definitely. And the technology is increasing with the passage of time. It's increasing very rapidly, and so do the challenges. And the fact that now there are specific guidelines, and governments all around the world, they are coming up with specific laws on AI that are not just focusing on the personal data processing, but also other forms of violations that AI systems can result, for example, discrimination and other societal biases. And they are going into specific regulations. Yes, I mentioned that there are existing data privacy laws that have provisions that can be applied to AI systems, but now governments are also coming up with specific laws that companies should be mindful of. So, and companies will have to the AI systems, they will have to uh, take care of both. They will have to take care of data privacy obligations that are that are present in the existing data privacy laws, as well as any new obligation that are coming in AI specific laws. And most AI specific laws would refer to privacy laws of their jurisdiction, that for personal data processing, you will have to follow those provisions. But it's definitely a challenge for AI systems, especially the technology keeps changing, and especially due to the fact that there are so many guidelines and standards in place now, and all of the regulatory bodies are suddenly into action. The UK Data Protection Authority is releasing its own UK AI risk assessment toolkit. Then we have NIST AI risk management framework that has different steps, and it talks about measure, manage, map, and govern steps for AI risk assessment. Then we have Singapore AI risk assessment framework. Finland has issued a separate AI risk assessment framework. So all of these frameworks and standards are in place, and then companies, yes, they can choose depending on which region they operate in, and depending on which privacy laws apply to them. But they would also need to select from industry best practices as to which of these standards should be an industry best practice suited for their business. And if that the business is global and they have offices in multiple locations, then the challenging task would be, why do they have to conduct multiple AI risk assessments? Or is there a way that they can conduct one single risk assessment that can cater to all the guidelines and all the regulations at the same time? they would want to look for common denominators from all these standards and guidelines and come up with a common solution for AI risk assessments. So it's a challenge. Definitely, it's a challenge for AI systems and companies.
Yeah, for sure. So just in terms of going forward with these new specific AI regulations that you mentioned as well, like the EU AI Act. So how do you see the obligations and practices and compliance related obligations of organizations changing, if at all, with the emergence and advent of these new regulations? Because it seems like that. So far, data protection and privacy laws have been doing the heavy lifting in terms of trying to regulate AI systems as they're being, deployed and coming, out every day. It seems. So how would that change the regulatory landscape and the practices of organizations when we actually have these regulations in place? I know it's a bit of a future prediction sort of a scenario,
Yeah.
but yeah, how do you see that?
So one thing is, it's very noticeable that AI risk assessment will definitely be part of the overall
Yeah,
privacy assessment. The regular privacy assessments that companies perform for before they any process or for general data processing activity, it will include the AI risk assessment in itself if it involves an AI system. So it will become part of the privacy assessment. And as I mentioned earlier, that at the same time, there will be specific AI risk assessments as well, because of the specific obligations that we are, we're imagining that AI regulations will impose. There will be an increased obligation of transparency. In my understanding, there will be an increased obligation of documentation under the AI regulations that will come into place, and there will be an obligation of conducting the risk assessment. It will be made part of the laws, the AI regulations, and how that risk assessment should lead you to mitigate the risk. So, like, in addition to the basic data protection principles that would be applicable to AI systems, I also think there will be an increased focus on transparency by the regulatory authorities and increased focus on documentation by regulatory authorities.
yeah, for sure. No, yeah, I completely agree. So before I let you go, so just in terms of the people who will be and are responsible for governing AI systems and working in this area. So it seems like privacy professionals have become the natural successors to people working in AI governance, as it seems that a lot of existing you know DPOs and privacy professionals and privacy solicitors and lawyers are sort of taking up on the challenge of legal implications of AI systems as they're being deployed and as they're being used around the world. So, how do you see the role of professionals, especially data privacy professionals, going forward to deal with the challenge of AI governance?
Yes, for sure. Data privacy professionals, they need to start learning about what is happening in AI side of the law, and as AI laws are coming into place, because privacy professionals, they are also reading through the laws and understanding laws, and AI laws cannot be made separate. They have to be read together with data privacy laws. So that is something data privacy professionals, especially lawyers, privacy professionals who come from a legal background, for them, for sure, AI governance is going to be a very central point of learning for them. But in addition to the privacy professionals that come from a legal background, we see that there are privacy professionals involved in different stages. For example, there are um, developers who are involved in in a software that relates to data privacy, and they also have to comply with data privacy laws. I think now we need to expand, understand the AI life cycle over here, and the different actors that are involved in the AI stage. There are AI design actors who are responsible in the input phase or the design phase of the AI lifecycle. Then there are AI development actors, where there can be software developers or engineers, and then there are AI deployment actors. And every single stage of the AI have different actors and different professionals, and these are the same professionals that were previously involved with any with their role can also be, what we say, it can be matched to the role of privacy professionals, because these actors, when they are in every separate stage of the AI lifecycle, they have to be mindful of data privacy obligations. Now they will also have to be mindful of what obligations specifically do they have in relation to the AI. So it is therefore important to identify the actors at every stage and understand their responsibilities. And I think none of us none of us can go away without understanding the responsibilities in relation to AI. It's very important for us, for all the professionals in every different stage of the software development life cycle, to understand what specific responsibilities they have in relation to the AI.
Yeah, for sure. No, I think yeah, I couldn't have said it better myself. Just in terms of the interdisciplinary nature of AI governance, it requires collaboration from legal, IT, product design teams, and all teams that work in an organization. So just in just before we end this discussion, so in terms of young students or law students, it doesn't have to be law students who want to enter the field. Of either data privacy or increasingly of AI governance, which is an upcoming field. Based on your experience so far and how your journey has been, uh, what advice, if any, would you have for anybody who wants to enter this field? Because people are increasingly developing an interest in this area, and it seems like it might be one of those industries which might not be affected by the jobs that are being lost due to AI,
Yeah.
emergence. So people are, saying, might as well regulate this phenomena if it's going to affect our jobs. So yeah. So what is your, do you have any,
Well, and
advice?
there can be an AI system, that can answer questions from a lawyer, just like we have Chat GPT. So there can be AI
Yeah.
systems that may affect our jobs as well. But
Yeah. Right now, it's giving away fake cases. I mean, the Chat GPT gave
yeah,
fake cases to a associate that didn't end up well. But yeah,
yeah, but
please.
positive thing is that we lawyers, we just do not read the laws, or we just do not read the guidelines. We have to interpret the guidelines,
Yeah.
and we have to read multiple documents together, laws along with the guidelines, along with the court decisions, and we have to interpret together. So yes, that's a positive thing. Probably lawyers will always retain their, they will have their jobs.
They'll find a way.
Yes, they will find a way. One advice that I would like to give to people who are new to this field is we need to stay updated on what's happening. Regulatory bodies, they're always in action, and they are taking enforcement actions very rapidly. So we need to stay updated on what's happening, is if there is a new law, what provisions have changed, what action the regulatory bodies are taking all around the world, and on what basis they are taking those actions. Because AI systems are changing, and as we will notice as we will go along, that AI systems are changing, the technology is changing, but at the same time, the laws will also keep evolving. So we need to stay updated on what's happening in the legal side, and you need to stay updated on the new legal developments, on in relation to AI and data privacy. That is
What
that's
about certifications? Are they important? What role do they play?
Yes. Well, I think the certifications definitely are important, and it also depends on which career pathway you want to move. For example, if you have a legal background and you are interested in data privacy, and you want what career pathway you are imagining for yourself. Do you want to work as a counsel who will, help your own company in data privacy related matters? Then do you want to work in a product related company where you are producing products that help other companies comply with data privacy laws? So there are two directions in in the path in data privacy field. You can work as a counsel of a company in the compliance department, where you can help the company itself to comply with data privacy laws. But then the other pathway is where you can be associated with a company that is producing AI related software like Security. And there are other companies as well which produce AI related software to help other companies comply with data privacy laws. Um, that is not related to internal compliance, but it's like how you are facilitating your customers and your the clients comply with data privacy laws. um, and certifications are definitely important, because the certifications, they build your foundation on data privacy. And depending on what career path you want to take, you would understand which certification would be ideal for you. For example, if you want to become a privacy manager, then the certification of CIPM will be very important for you. It sets the ground on what are the stages of the privacy management, and how you can ensure that data privacy is being managed throughout your company. And if you want if you do not want to come into privacy management area, perhaps then CIPM would not be relevant for you, but some other certification would be relevant for you. So certifications are important, definitely, but depending on what career pathway you want to take, because even data privacy field is wide and you can have different roles in the company. So depending on your role
Yeah.
within the company, the certification, which certification will be better for you, that would depend on your role within the company.
Yeah, for sure. And you don't even have to be a lawyer if you want to enter this field. A lot of people who don't work as a counsel, they always don't have a legal background. I mean, you can get these certifications even if you haven't been to law school. I know a lot of people who work in the privacy space, who come from different backgrounds, and not a legal one. So yeah, so that's something that one should keep in mind as well. But
Yes.
yeah, I completely agree with your suggestions and your advice to upcoming privacy and AI governance professionals. Great. Thank you so much, Maria, for taking out time and giving us this primer on what's happening in the AI governance world and what's it all about. So yeah, thanks so much for your time. It was a pleasure speaking with you,
Thank you
and
so much for
that's
having me.
all for sure. And that's all we have for this episode. And yeah, I'll see you in the next one. Thank you.